I have been Mr. Copeland's attorney. He tells me that he repeatedly told you that told you that when you were questioning him. I also spoke with Don Geary extensively about Mr. Copeland when he was assigned to this case, and I spoke with Ms. Love. I spoke with Ms. Love early in the process, around the time jury selection was beginning. I have a plea with Judge Carnicel tomorrow at 9 o'clock, and I will come to the courtroom as soon as I'm done.
Is everything that you responded about being Mr. Copeland's lawyer for purposes of this case true?
Yes.
Okay. And the court already admitted number 2. If you could go to number 3.
Well, no, I haven't.
Oh, I'm sorry. I moved for the admission of Mr. Williams, number 2.
It's admitted, and that one contains both Ms. Hilton's response and then Mr. Melnick's response back that he just read. Is that correct?
Yes.
Okay. It's admitted.
Okay. This is a repeat on the drawings. Okay. Okay, if we go to Mr. Williams, number 3, can you take a look at this and tell us whether you recognize it, and if yes, what is it?
It's a.
You just have what that is. You don't have numbers on it. I could just have what it is that we're considering.
I don't know. I don't know how many things you got handed, but Mr. Melnick's about to describe it.
It's dated June 7th, 2024, 11:52 a.m. It's from me to Ms. Hilton and Ms. Love. The first sentence says, "Here is a communication between myself and Ms. Love, which pertains directly to the YSL case." And it's a forwarded message from a number of people, including myself and your case manager, Sheila Rosser, dated March the 3rd of 2023. And it's from Ms. Love, stating, "Good morning, Ms. Rosser. State asks that the defendant be required to sign the conditions in front of a notary or a sheriff's official so that we can enforce the conditions upon his release, since he was not apprised by the court in person." And I'm sorry, that is in reference to 2 bond orders, I believe, that I had prepared and presented to the court in reference to Mr. Copeland's case that was pending before you in 2023. That is an email dated Thursday, March 2nd, 2023 at 4:42 p.m. And this is just a chain of emails related to the bond order for Mr. Copeland's case in 2023.
All right, and you're forwarding that in June of 2024 to say, see, you knew at some point I was representing him. Okay.
That's correct, Judge.
That document is definitively a 3-page document, or just the one portion of the chain that you just read?
So is this a continuation? Yes. Great. Okay. There's more to it, Ms. Love.
Is it a 3-page document?
It appears to be. I think it appears to be a 3-page document. Yes.
Yes. Yes. Okay.
I don't need to read all of this.
No, I don't think so.
We move for the admission of Mr. Williams, number 3, for purposes of today's hearing.
It's admitted.
Why did you, Mr. Melnick, why did you send this to the district attorney's office on June 7, 2024, 11:52 a.m.?
Because of what they claim to be the confusion as to whether or not I was representing Mr. Copeland for purposes of his being a witness in this case. I think these emails demonstrate that I did in fact represent him and that they knew I represented him.
And were there conversations that you represented Mr. Copeland for the witness in the YSL case during that time?
Yes, there were.
And who did you speak with?
Ms. Love.
Okay. And you're responding to Mr. Williams, number 2, that's already in evidence?
Yes.
All right. Your Honor, I move for the admission of Mr. Williams, number 3. It is a 3-page document.
It's admitted.
And I'm going to mark this as Mr. Williams, number 4. Can you take a look at this and tell us if you recognize this and what is it? Okay. And what is that?
It's an email that I also sent on June the 7th, 2024 at 11:54 a.m. To Ms. Hilton and Ms. Love, referencing another communication I had from the district attorney's office. It was a forwarded message from Peachtree Offices, which is an executive office a company that answers my phone for me, where I got a message from Peter Herzog asking me to contact him in reference to Kenneth Copeland. So it's a forwarded message from June the 27th of 2023 that I then forwarded to Ms. Hilton and Ms. Love, demonstrating that they should have just communicated with me about Copeland before questioning him.
And go ahead. I'm sorry.
And before we got into all this.
And who is Peter? And I'm going to spell the last name, okay?
Yeah.
Herezog. Who is that person to your knowledge?
I believe his last name is misspelled there. I think it's Herzog, but Peter Herzog is the assistant DA in the Fulton DA's office.
And Mr. Williams, what's marked as number 4, is sent for that message on June 27, 2023, about 3 months after the March 1, 2023 correspondence with Ms. Love about Mr. Copeland.
That's correct.
Now, if your representation of Mr. Copeland had in fact ended when you disposed of the case before the Honorable Judge Whitaker, by that time, do you remember? Did it end?
So my case with Judge Whitaker, is that what you're asking me about?
Yes.
Yeah, I believe it had, but honestly, I haven't gone back to check.
If you have the case number, I can look it up and let you know the disposition date.
I don't
I'm
have.
happy to do that. Nobody has it.
And maybe
It was a 22 SC case, but that's all I know. It's fine. I can probably pull it up some other way. Y'all go ahead.
Okay. And you forwarded this, you said why? This message.
To reiterate the fact that the DA's office, the Fulton DA's office knew and should have known that I was representing Mr. Copeland for purposes of his testimony in the YSL trial. Mr. Herzog was never involved in the case before Judge Whitaker. I've never spoken with him about anything related to the case in front of Judge Whitaker. The only attorneys that I ever spoke with about the actual disposition of the case with Judge Whitaker was Abigail Potter, Abby Potter from the DA's office, and Mr. Abadi. And the only reason Mr. Abadi was involved with it, that's Adam Abadi from the Fulton DA's office, was because he was concerned about Mr. Copeland's testimony in the YSL trial.
And obviously Ms. Love, because she
And yes, right, and he's raised the bond order, that's correct.
Okay. Now, I'd like to show you Mr. Williams number 5. Oh, you're on, I move for the admission of Mr. Williams number 4.
It's admitted, and for purposes of the record, the case before me where Mr. Melnick represented Mr. Copeland is 22 SC 182134, and the final disposition was actually on June 29th of 2023.
Number 4 is 1-page document, or are there any more?
It's a one-page document.
Okay, I'm showing you Mr. Williams number 5. Tell us if you remember that, look at it. Okay, and is it accurate? Can you describe, like you've been doing, the date and time, what it is, what it purports to be?
It's dated June the 7th of 2024. It's to Ms. Love and Ms. Hilton from me, and it is in response to an email that I received. I'm sorry.
It's okay. You can look at the documents multiple.
And so this is a part of the same chain of documents where I was referencing the fact that Ms. Love certainly knew that I was representing Mr. Copeland. She and I talked extensively about Mr. Copeland, and she had told me that she wished to use Mr. Copeland as a witness in this case. Obviously, by the time we were having these communications in March of 2023, the case had long since been indicted, and Mr. Copeland was not charged as a party on the indictment of this case. So this is a continuation of the same emails going back to March 2nd and March 3rd of 2023, where we're referencing the bond orders. These emails actually go back to March 1st of 2023, where Ms. Love is discussing whether or not Mr. Copeland should be subject to a curfew as part of his bond order. There are, I seem to remember, other communications in which Ms. Love references the fact that she's concerned about Mr. Copeland's safety and the like. And then so the last part of this email, which is at the top of the first page, is where Ms. Love questions whether my concern is for Mr. Copeland or Mr. Steele and Mr. Sharp's client, neither of whom I've ever met or had any relationship with whatsoever. And then I responded to that.
Did I ever do anything untoward to affect your representation of your client, Mr. Copeland?
Absolutely not.
Did Mr. Shard do anything?
No.
Did anybody come to you, at you, about your representation, Mr. Copeland, in this case?
What Mr. Copeland did on June 7th of 2024, where he asserted his Fifth Amendment privilege, was entirely his decision. I was there just as his mouthpiece, as a lawyer, as his advocate for purposes of him asserting his Fifth Amendment privilege. Other than that, I had absolutely no agenda in this case whatsoever.
When Ms. Love wrote on a motion, ex parte motion for the former judge, the recused Judge Glanville.
Now, I'll object to the introduction through this witness or the posing to this witness of any question about a motion that I wrote, given that the witness cannot testify confidently about anything that I specifically wrote of, but I.
All right, well, I don't know yet what the end of the question is going to be, so I'll hold your objection until I hear the question.
And it's in the record. Already, Your Honor, I can get another copy of. Ms. Love wrote in that motion seeking use immunity under 25-5-507 for Mr. Copeland.
Yes.
That Mr. Copeland on Thursday, June 6, 2024, had some sort of interaction or dealings with members of the defense team. To your knowledge, is that true?
I have no knowledge of that.
All right.
Do you want to admit, or did you want to tender for admission Williams 5?
I do, yes.
All right, that's admitted.
Thank you, Your Honor.
And Williams 5 was what?
Okay, Mr. Melnick, I don't have any other
Hang on. What are you
questions.
asking? Hang on, Mr. Steele. What are you asking? Just what it is?
Which one is it? Yes.
It's the last one they discussed that, I don't know how many pages it is. I don't have any of it in front of me, but it's the last one they discussed that has the email from you asking who Mr. Melnick is most concerned about or something like that. And then Mr. Melnick's rather peppery response back.
Okay, so it's just, for the court clarification, just one page or?
I don't know. 4 pages.
Mr. Melnick, were there any BCC? You know what a BCC is?
Yes.
Okay, I apologize. Fast.
Yes.
Is there any?
We're all old enough to know that that means the line carbon copy. A whole lot of people don't know that anymore since we don't use carbon copies, but that's where somebody can see it, but the recipients who are CC'd don't know.
Yes, I did not blind copy anybody on that last email. I just sent it to Ms. Hilton and stuff.
Any
I told them stuff.
I apologize.
Yeah.
Any allegation that there was some sort of teamwork or conspiracy against the state of Georgia and against your client, Mr. Copeland, is that true at all?
It is categorically untrue.
I want to thank you so much. I don't have any other questions.
Ms. Love, do you have questions of Mr. Melnick? Hang on just a second.
Just briefly.
Okay, hang on. You have questions too? All right, I'll let Mr. Sharp go.
And those are the court's copies.
Okay.
Mr. Melnick, if you're more comfortable taking the witness stand, that's fine, but, okay.
Mr. Melnick, good morning.
Good morning.
As part of your representation of Mr. Copeland, as part of your representation of Mr. Copeland,
Yes, sir.
did you also make it known? Did you make your representation known to the defense counsel in this case, specifically myself and Mr. Steele?
I did. Yeah.
Okay. In your dealings with the defense in this case, have myself or Mr. Steele ever gone behind your representation to your knowledge and attempted to speak to Mr. Copeland without your knowledge and understanding?
I have no knowledge of that. I'm not aware of any time that would happen.
Since you were alerted about the state speaking to Mr. Copeland, have you read the transcripts from the ex parte communications?
I have mostly read them. I'll be honest and say I haven't read the whole thing.
Okay. Have you become aware that Mr. Copeland was speaking to the state in the week leading up to June 7th, 2024?
Yes.
Okay. Have you become aware that Mr. Copeland was in the actual courthouse speaking to the state on that week?
I became aware of that on either June 6th or June 7th.
Did you know anything about that as it was happening?
I did not.
Before you reached out to the state via those emails that have been introduced, did the state ever tell you that they were communicating with your client?
No.
How did you initially learn that the state was communicating with your client?
Are you referencing the week of up to June 7th of 2024?
Yes, let me ask in a more precise manner. Did you become aware on Thursday, June 6, 2024, that the state had been speaking to your client that week?
Yes.
And did you become aware that the state intended to call your client to the stand on the next day, that Friday?
Yes.
Okay. Did you, and how did you find out about the state's plans to call your witness to the stand?
I believe you called me.
Could you say it again?
You called me.
You being Matt Sharp?
Yes.
Okay. And I called you on the telephone?
Yes.
Okay. In that conversation, did I ever ask you to do anything on behalf of myself or Mr. Steele or our clients?
Absolutely not.
Did I ever ask you to stop Mr. Copeland from testifying?
Absolutely not.
As a lawyer, is it appropriate to contact another lawyer about their client?
Objection, Your Honor, as to this witness being qualified to speak about what are the ethics.
I would hope that every lawyer in the state of Georgia is qualified to speak on what we're expected to do under our code of ethics. I'm going to overrule that.
Would you repeat the question, please?
In your experience as a lawyer, is it appropriate for another lawyer to contact you about matters concerning your client?
That's law school 101.
And is that what I did on Thursday, June 6, 2024?
Yes.
Mr. Melnick, before you got in, well, your testimony is you were involved representing Mr. Copeland
Yeah.
throughout this entire period, correct?
Mm-hmm.
Before you emailed the district attorney's office about their communications with your client that you were unaware of, to your knowledge, had Mr. Copeland been granted any sort of immunity or legal protections for his testimony?
To my knowledge, no.
Okay. After you contacted this district attorney's office and actively communicated with them about your client, what protections was Mr. Copeland granted?
Use immunity.
I have nothing further.
All
Thank you.
right. Any other defense attorney with questions for Mr. Melnick? All right. Hearing no other. Go ahead, Ms. Love.
Thank you, Judge. Mr. Melnick, I'm just gonna be a little bit brief and I'm gonna clarify some things. Is Defendant Williams exhibit? Yes, Mr. Hart.
Or speak just more loudly. Or around the, yeah.
I'll take this stand.
Okay.
I just can't put these.
You can leave it.
Okay.
Does somebody have a copy of those exhibits for the court?
Judge, I'll give to the court the ones that he has admitted and I'll just go ahead and use the ones that I have copies.
Okay. Thank you. towards you and make sure he's on. Mr. Melnick, should be some button somewhere.
See where it is?
Screen's green.
I don't actually see it. It sounds to me like it's on.
Yeah, sounds like it's on.
Yeah.
All right, go ahead, Ms. Love.
Thank you, Judge. Mr. Melnick, and Your Honor, I'm going to use, unless the court instructs me otherwise, I'm going to use the copies that I was given that I've marked as defendants the way that they've indicated they should be marked exhibits.
Okay.
Okay. Mr. Melnick, I'm showing you what is the copy of Defendant's Exhibit 1
Yes.
that was given to the state and to the court. Is this an exact copy of Defendant's Exhibit 1 that I'm showing you?
I believe so. I mean, I haven't printed them up. I don't know if there was another email that was.
Y'all are welcome to do these things if you want. That doesn't need to be an issue. I mean, they were handed to you, Ms. Love, by Mr. Steele, right?
Yes, Your
All
Honor.
right, then they ought to be exact copies.
May I, my person didn't.
Just a second. Mr. Harvey, yes, can you not hear? Me? Okay, sorry. I was just saying, I'm sure that the copies are the same, but if she wants to use the admitted copies, she can. I'll trade you. How about that?
Yes.
Just make sure you get the admitted copies to the court reporter when we're finished with this.
Yes.
Thank you.
So showing you what has been admitted as Defendant Williams Exhibit Number 1.
Yes.
Looking at Defendant Williams Exhibit Number 1, is that an extraction? In other words, is that a portion of an email cut out and isolated from a larger email?
I don't believe so.
Okay. Then I'm going to show you Defendant Your Honor, I just may need the portions that I gave to the court, because I don't see.
All right, here you go.
Yep. Thank you. Sorry. All right. Showing you what I will mark as State's Exhibit 1, copy of Defendant Williams Exhibit 1, Melnick offer. And I was provided this by Mr. Williams, Your Honor.
By Mr. Steele.
Yes. Could you look at what I've now labeled as State's Exhibit 1 and compare it to what has been admitted as Defendant's Exhibit 1 and tell me whether or not those two documents, State's Exhibit 1, just for the purposes of the record, is a one-page document. Could you tell me whether these two documents contain the content from the same email?
So the content appears to be the same, other than the fact that on the one that you just marked, there what appears to be the seal from the Fulton County, the Atlanta Judicial Circuit.
And in fact, the one that I've marked as State's Exhibit 1 is the actual email that Mr. Steele would have had access to, correct? It's a portion of the actual email chain, given that it has that seal on it.
Very often, if I'm sending an email, I'll just pick up from the last email that I sent to or from that individual. So that may well be, there may have been a prior email that I mean, if it was between you and I don't remember exactly when it was.
I'm showing you what has, I believe, been marked as Defendant Williams Exhibit number 2. Let's see if those two match. Give me 1 second, okay? Defendant Williams Exhibit 2. So, you agree with me that Defendant Williams Exhibit 2 is in fact the top portion of the email that I have labeled and tendered as State's Exhibit, but not yet tendered, but labeled as State's Exhibit 1?
Yes, that's correct.
Your Honor, the state tendered State's Exhibit 1 just as evidence.
All right.
All right? Now,
Admitted.
thank you. So, looking at Defendant Williams Exhibit 2 and State's Exhibit 1, are you able now to say with any more clarity that Defendant Williams Exhibit 1 is a document, a piece of paper where a portion of the email chain that is contained within Defendant Williams 2 and State's Exhibit 1 has been extracted and pasted onto a piece of paper?
So I can't speak for how Mr. Steele printed this up. I wasn't there in his office when he did that or whenever somebody in his office did that. You are correct that what has been marked here as Mr. Williams Exhibit number 2 is part of a chain of communications between myself, yourself, Ms. Hilton, Mr. Steele, and Mr. Sharp. Looks like there's a CC to Antonio Long as well. Yeah, so but these emails were sent after the State's Exhibit 1, which is also Mr. Williams Exhibit number 1. These emails dated, so you can see here, Ms. Love, this is dated June 6, 2024, 5:47 p.m. Yeah, this is dated June 6, 2024, 4:31 p.m. Right. So this is just part of the same line of communications that we were having, where I said, Mr. Copeland doesn't want to plead, doesn't want to testify, wants to take the fifth. Ms. Hilton responds, and then I respond to her response. And in her response is where you get your insignia for the Atlanta Judicial Circuit.
Okay, so let me be clearer. The exhibit that is labeled Defendant Williams Exhibit 1, did you ever forward that separately to Mr. Steele or Mr. Sharp?
I think I just forwarded. I mean, I wouldn't have had to because they got the emails. Right.
Okay.
So they got this email initially.
Y'all, when y'all are saying this email, we have no idea what you mean. Can you refer to the exhibit numbers?
They got Mr. Williams' email number 1, exhibit number 1, which is the first email from June 6th at roughly 4:30 p.m. Then there was a response from Ms. Hilton, June 6th, 4:57 p.m.
And that's Mark Williams 2.
Williams 2, thank you. And then I responded to that June 6th, 5:47 p.m.
Okay, so
And that's also on Williams
2,
right?
yes.
Yeah, okay.
So, as it pertains to my original question, Defendant Williams Exhibit 1 was never a communication that you sent separate from the emails that are contained in Defendant Williams 2 and State's Exhibit 1. Is that wrong or right?
That is wrong.
Okay, so you sent, without forwarding the rest of what is labeled as Defendant Williams 2 and State's Exhibit 1, you sent an email that contained only the document that is labeled Defendant's Exhibit 1 to Mr. Sharp, Mr. Steele, Ms. Hilton, and myself.
I sent it on June the 6th at 4:30.
Right. And do you also see June 6th at 4:31 p.m.? When you say 4:30, you do mean 4:31 p.m.?
Yes.
Do you also see June 6th, 2024 at 4:31 p.m. on the email State's Exhibit 1?
Yes.
And in fact, the email State's Exhibit 1 is at the bottom, meaning it came before
Yes.
the emails that were Defendant Williams Exhibit 2.
That is correct.
Okay. And so, given that State's Exhibit 1 looks as it does, are you saying that the email that is Defendant Williams 1 is the entirety and not a part of any other email chain that you said.
This email was the first email sent. Okay, so when I say this email, I'm referring to Mr. Williams' exhibit number 1.
Okay.
Was the first email sent on June the 6th of 2024.
Okay.
That is the first email. Mr. Williams' exhibit number 2 is the continuation of that chain of emails in which Ms. Hilton responded to me, and then I responded to everybody else, including yourself.
Thank you for clarifying. Your Honor, I'm going to give back to the court's copies of the emails.
Okay.
Thank you. And I apologize, they're not.
That's. Thank you.
You were asked, Mr. Melnick, about. You were asked by Mr. Sharp, how did you become aware that the state was talking to Mr. Copeland?
Okay. Let's try to figure out where that squelch is coming from.
Might be for me, I may have been too close
Okay,
to my
where's state's one, Ms. Love?
And Your Honor,
If you got-
that's in your.
Yeah, you did, it's submitted. Thank you.
Did we clear up the squelch? Is it gone?
It seems to be.
Who did it? Is it the court tonight? Oh. I'll step away from it so that I'm echoing. Mr. Melnick, do you remember Mr. Shard asking you, how did you become aware that the state was talking to Mr. Copeland?
Yes,
And did you understand that question to me in 2024?
leading up to June 7th of 2024, yes,
Did you answer how you became aware that the state was talking to Mr. Copeland?
I did,
How did you become aware?
because Mr. Sharp told me.
Okay. And when Mr. Sharp called you, was that the first time that you were aware that the state had been talking to Mr. Copeland?
Since, I was aware of an interview that took place with, I think it was investigator Viverito. I don't remember the date of that interview, but it was during a time when I was representing Mr. Copeland. But other than that particular communication, that was the first time I became aware of any direct communication between the district attorney's office and Mr. Copeland.
And when you speak of the interview by investigator Viverito, was that while she was with the DA's office or while she was with the Atlanta Police Department?
I do not know.
And was that interview one that you had seen or have knowledge as a part of the discovery in this case, or something different?
I have knowledge of it. I've never seen the interview. I know that it exists.
And was that interview a formal interview while he was in custody at the jail?
Yes, as I recall. I haven't seen the interview, but I believe he was in custody at the time.
And did you give permission to that interview? I'm gonna turn this off.
Just speak loudly.
Did you give permission for that interview, or did Mr. Copeland reach out to investigator Viverito to talk to her?
I have no idea. I did not give permission for that interview. I do not know if Copeland reached out to her or not.
And had you been paid by Mr. Copeland or retained by Mr. Copeland to represent him on criminal charges at that time?
Yes.
And was that prior to March of 2023 that this interview took place?
Yes.
Do you recall at any time representing to any member of the district attorney's office in 2023 that Mr. Copeland had not paid you for your services?
No.
Do you recall telling a member of the district attorney's office that you were not representing Mr. Copeland on his criminal charges because he had not paid you? I'm just asking if you remember. If you don't, that's
I
fine.
don't.
Okay.
No, I represented him in his criminal charges to the end.
We understand.
Yeah.
And when Mr. Sharp called you, what was it? What did he say to you exactly?
He said that Mr. Copeland was being called as a witness the next day, June 7th of 2024.
So at what point how did he tell you that the state had been talking?
during the course of that conversation.
What did he tell you, sir?
He just said that the state's been speaking to Mr. Copeland.
How many times have you spoken with Kenneth Copeland between the time that Mr. Sharp called you and the time that you resolved his criminal matter before?
How many times did I speak with him between June of 23 and June of 24? I mean, I can't give you an exact number, but Mr. Copeland has always been in communication with me.
Did you speak with him more than one time?
Yes.
And during your communication with him, did he always have access to your phone?
Always.
Did he appear to always be aware that he could reach out to you at any time?
This is something where we're going to have to, I don't feel comfortable.
I can stop and pull that question all the way back.
All right.
And the court can decide if the next question is privileged. Did you assure Mr. Copeland?
I'm not going to talk about anything I said to Mr. Copeland. Period. I'm not going to talk about anything that I said to Mr. Copeland.
Okay. Based on how you have already testified, is it safe to say Mr. Copeland did reach out to you and say to you?
I'm not going to talk about any communication I had with Mr. Copeland.
Do you have any idea why it would be Mr. Sharp who first alerted you that the state was talking to Mr. Copeland?
No.
And are you aware of any communications Mr. Copeland made to state as it pertains to your representation of him get after his criminal case was resolved?
I don't know.
Do you recall, you indicated that you spoke with Mr. Abadi in the district attorney's office regarding Mr. Copeland as a witness in the case that we are in trial on.
Yes.
Do you recall telling Mr. Abadi that you were not representing Mr. Copeland beyond the criminal case?
No.
Was the time or times that you spoke with Mr. Abadi in the context of resolving or getting a bond for Mr. Copeland's criminal charge?
It was primarily with regard to the bond and the underlying criminal charges. I don't believe Mr. Abadi has much of any involvement in this case.
What is your recollection of what it was that you said to Mr. Abadi or anyone else regarding your representation of Kenneth Copeland beyond his criminal charges?
I don't really recall having, other than the fact that, he's talked to me and I've talked to the state, I don't recall having in-depth conversations about it. Y'all were still in the middle of jury selection. It wasn't much of an issue.
Understanding you don't recall having in-depth conversations about it, what is it that you recall telling Mr. Abadi or any other member of the state about your representation of Kenneth Copeland beyond his criminal charges?
I don't really have any independent recollection of anything specific.
How are you then able to say that you spoke with members of the state and told them that you represented Kenneth Copeland in his capacity as a witness in this trial?
Because I had specific conversations with Don Geary about this case and about Mr. Geary's desire to use Mr. Copeland as a witness.
Am I correct that that was pre-indictment?
Yes.
And am I correct that that was at a time when there was at least a prospect that Mr. Copeland would be a defendant and not only a witness?
That's correct.
So, apart from the conversation you had with Don Geary pre-indictment, where there was a prospect that Mr. Copeland would be one the indictment, do you have any recollection of conversations that you had with members of the district attorney's office regarding your representation of Kenneth Copeland as a witness in the current case 22 SC 18357?
Ms. Love, we did not have substantive discussions about what his testimony would be. But everybody in your office knew that I was representing Kenneth Copeland.
But with respect, I don't mean substantive, I'm asking you simply, do you recall what it was, if anything, you said to either Mr. Abadi or any other member of the district attorney's office regarding your representation of Kenneth Copeland as a witness only in the current case 22 SC 1835?
Just that I'm representing him.
And you recall specifically saying to some member of the DA's office, apart from the criminal charges that you helped resolve in 2023, you recall saying to a member of the district attorney's office, I'm representing Kenneth Copeland as a witness only in the YSL trial.
I said that to you,
That
okay?
is your memory.
Yes,
Where was this? Is it on the phone?
yes.
Okay. And what was it? Was it before or after Mr. Copeland resolved his criminal charges?
I guess before, because it was when we were talking about the bond issue.
And so what exactly did you say about your representation?
I said that I was representing him, and if you want to talk to him, talk to me.
And when you said you were representing him,
No, Miss Love, it's not true.
did
And
you state that you were representing him beyond the criminal charges?
Have you finished your answer?
that's fine, yes.
Make sure he finishes his answer before you put the next one on the floor, okay?
Did you state that you were representing Kenneth Copeland in his capacity as a witness in the 22 SC 183572 case
Yes.
outside of the criminal charges?
Yes.
And did I hear you say that it was your testimony that you never once indicated that Kenneth Copeland had not paid you and you weren't even representing him in the criminal case?
No.
So is it also your testimony that no one from the DA's office reached out to you to try and get you to go speak with Mr. Copeland
About what?
about his criminal charges?
Nobody tried to reach me to go talk to Mr. Copeland about his criminal charges.
Is that your testimony?
I don't know why that would be necessary.
And that wasn't my question. Answer the question.
No, I don't recall anybody speaking to me about going to talk to Mr. Copeland about his criminal charges.
And so is it fair to say you also don't remember telling any member of the DA's office that you were on vacation and you were not able to deal with Mr. Copeland's criminal charge?
So I resolved Mr. Copeland's criminal charges. As far as I know, I resolved them to Mr. Copeland's satisfaction. And it may well be that at some point I was on vacation and not available to go speak to Mr. Copeland. I don't recall specific dates and times, but there is no issue with communication between myself and Mr. Copeland. Okay?
So as it relates to the question that I asked, do you recall there being a time when you conveyed to the district attorney's office that you were on vacation and could not go to talk with Mr. Copeland?
Ms. Love, if you have such a communication, then I'm sure it exists. The fact that I may have been on vacation a day or a week doesn't mean that I wasn't communicating with my client. Okay?
And if you wouldn't mind answering whether or not you recall it or not.
I don't recall.
All right, y'all, we've been at this for over an hour and it's really not particularly relevant anyway, so let's wrap things up.
Yes, Your Honor. When you spoke about Mr. Herzog and you said he's never involved in case, do you know what it was that he was talking about?
He was calling me about Mr. Copeland testifying in the YSL trial.
And you spoke with him
Yes.
and he said that?
Yes.
And what did you tell him?
I told him that Mr. Copeland didn't want to testify.
Now, that was in March.
That was in June of 2023.
And did Mr. Herzog ever say he was working on that trial?
That was my understanding of the purpose of this call to me.
Did he say he was working on it?
Yes.
You indicated, and Your Honor, I have about 5 more questions.
All right.
You indicated that, upon questioning by Mr. Steele that your concern regarding the district attorney's office communication with Mr. Copeland was Mr. Copeland's criminal exposure and that the DA's office was seeking use immunity. And that you considered it ironic that a motion would be filed on June the 7th, considering there should have been, or wasn't, apparently there was no grant of immunity prior to that time. Do you recall saying? You never once asked the district attorney's office what protections the immunity afforded to Mr. Copeland.
I'm familiar with what use immunity is, Ms. Love.
Do you recall telling Ms. Hilton in the presence of an investigator that you had never heard of OCGS 24557?
I believe that I did not know that that was the use immunity statute, but once I read the order and saw that it was the use immunity statute, I'm very familiar with use immunity. I've been doing this for 30 years.
And so you are aware then that there wasn't a need to seek use immunity, but that the motion was to compel Mr. Copeland to testify after the state had offered him.
I feel that the motion and the order that was granted to Mr. Copeland did not protect him very much at all.
And finally, in writing to the email that is labeled Defendant Williams Exhibit Number 5, you wrote, "My concern is for my client. Had I been involved, I would have demanded a much more specific immunity law. You need him much more than he needs you. You've put him in a terrible position where you know his life is in danger, whether in custody or on the street. He's a marked man from this point forward. Go after yourself if you think I'm doing anything besides protecting my client."
Yes.
So, what specifically did you intend to, you didn't include in here anything particular that you were worried about with the immunity law, but you were very specific about Mr. Copeland's potential danger from testifying. Is that wrong or right?
We all know that Mr. Copeland is in danger by virtue of his testifying here.
Now, are you asserting that he is in danger or any member of the state from testifying?
No.
And what specifically did you want, more specifically, in the, because you do understand it's not immunity deals. You can't use anything he says in any way against you.
Yes.
So understanding that, and that the motion was simply to compel Mr. Copeland to testify, given that he received that, what much more specific information did you want to see in the movie?
I would have demanded that he be given immunity from all state level prosecutions as a result of any action he may have had involved with any other individual in this case. And I would have seen if we could have included the feds in that as well.
And did you not understand Mr. Copeland, or did you want more than what he was entitled? Did you not understand him to have been afforded immunity or anything he was asked about criminally, whether it was from the state or the defense?
All that protects him from is from you using his testimony against him.
So you did not understand that it actually protected us from using that testimony in any way to get information about him, to prosecute him regarding those acts. You did not.
It protects him from his testimony at trial being used against him, Ms. Love.
And anything derived from that.
And anything derived from that testimony.
As we go to the side, anything derived from that testimony. Are you aware of it?
Yes, ma'am.
So, given that Mr. Copeland could not be prosecuted for anything he testified about criminally, and the state could not use his testimony to go seek additional information or reasons to prosecute him, What is it that you would have been seeking to get?
So we are getting dangerously close to privileged communications here. So, but I told you what I would have demanded. I would have demanded absolute immunity from any state level prosecution for any criminal action involved in this matter.
Even those that he didn't speak about at all,
Yes.
and could you tell us just why it is that you would have felt that that was
I think that's,
something that should have been avoided?
I'm not going to get into that.
Not.
I'm not going to get into that, Ms. Love. I'm not going to get into that.
I think that's all that. And
All right, is there any further questioning? Okay, Mr. Melnick, this time you can actually go. Thank you for your talk. All right. All right, let's move on to the next issue. All right, we're done with this, right? Everybody satisfied?
I'll just offer on the record, without calling unless the court finds it necessary, that, lawyer who was,
Hang on just a second. Yes, sir?
I do not accept any proffer by Ms. Love. I've told the court that before, but that remains.
All right.
I'm rejecting it.
No, no.
Fine, then that's fine.
Don't talk while somebody else is talking. Let him finish, let me rule, then you can go ahead. I will listen to what your proffer is, because it's really not for Mr. Steele to accept or not, it's for the court to accept or not. Go ahead.
that Mr. Abadi, who was, earlier, the president of work, was on the call that I think Mr. Melnick referenced that he had regarding, he said he was spoken to Mr. Abadi about Mr. Copeland and his representation of Mr. Copeland as a witness in this case. Mr. Abadi will testify that Mr. Melnick specifically and explicitly said that he didn't want to have anything to do with his YSL case, that he would not represent him in his capacity as a witness in this case, and that when he was done with criminal charges, that was it. I believe that he made some reference to Ms. Marcelson or something like that. I don't remember exactly, but if necessary, I will bring Mr. Abadi back at some point to testify.
All right, well, if I am presented with a motion that makes that testimony relevant, then we'll hear from him at that time. My point in all of this was just so that Mr. Melnick could feel like he'd cleared his name. All right. Okay, so, anybody need a restroom break before we move to